Hello, welcome to another edition of Matters of Law. This is our first edition for the year 2023. What was your most educative edition in 2022? Was it the talk on arrest, or on the court structure, or contract, or bail, or obtaining a permit? Today, we are discussing more or less a summary and a longer version of what we have been discussing on arrest, bail, court, and prison. Let's take a spot of commercial. We'll be right back.
This program is brought to you by PEG Enterprise. Call us on 0240 533 097, 0240 533 097 for your delicious pastries, cookies, and drinks. Locate PEG Enterprise near KK House in Ho.
Welcome back. Today we are discussing arrest, bail, court, and prisons. Now, this particular session will be a bit longer than our usual session, so please stick and stay and just get a full recap and a better understanding of how the legal processes are in Ghana when one is arrested till when one is probably put in prison. One of the things we need to understand is that when a crime is committed, the police is mandated to arrest such a person. Now, when you are arrested, investigations ought to be conducted. During the period of investigations, you could be granted police enquiry bail. You do not pay for bail. You could also be sent to court, and the requirement of the law is that if within 48 hours you have not been sent to court, then the police are required to grant you bail. However, within the 48 hours, they are also mandated under law to exercise their discretion to grant you bail. It doesn't matter whether you are arrested on a holiday or you are arrested over the weekend. 48 hours is 48 hours. The Supreme Court has given its decision on that and has stated specifically that even if the 48 hours ends on weekends, you are supposed to be placed before a court. I know a number of you are wondering the practicality or how that is going to work out. Well, it is still work in progress, and we would be waiting to see how practical or how efficient that would be worked on as a country. So let's move on. Once you are granted bail, you are required to be reporting. Now, the essence of the grant of bail is to ensure that you make yourself available whenever the police need you. Those who stand as sureties, their duty is to ensure that they produce you whenever the police need you. Now, if you fail to appear whenever the police need you, they can rearrest you because you have broken the bail conditions. So let's say you have been granted bail and they continue with their investigations. Whenever the police need you, you are supposed to be present. Now, the police need not seek the consent of the complainant in the case before they grant you bail. Meaning, the grant of bail is not at the discretion of whoever went to give the complaint to the police. So if you are a complainant and the police go ahead to grant an accused suspect bail, let me use the word suspect bail, you cannot complain and say that they didn't consult you before granting the person bail. In any case, the most prudent thing they can do is to alert you that yes, they have granted the person bail. They ought to let you know the stage of investigations. Now, assuming that complaint has been made and the person has been granted bail, the next thing they will do is to ensure that they conduct their investigations. The police are required under law to write every single step they take in their investigation in a diary of action. Now, every case docket that is built up, they do what we call a diary of action. They write every single step that they take in the case. Their arrest, visiting the scene of crime, any other thing they get, any evidence they gather, they write it in the diary of action. Now, that diary of action is in the compendium of what we call a case docket. So they build a case docket. That case docket will include your statement as a statement of a complainant, any other witnesses, or any other evidence that they have gathered. It will also include the investigation caution statement of the suspect who volunteers a statement, and if they establish that there's a crime or they have established there's a charge that they can put against you, then they'll obtain a charge statement from you, the suspect. Now remember, once they obtain a charge statement, then you become an accused person because they will put you before court. So if they are putting you before court, they need to let you know that they are putting you before court. Now they may file the case at the circuit court or at the district court or at the high court, depending on the kind of crime that the person has committed. You are entitled to a copy of what we call the charge sheet. The charge sheet is the one who gives the charges that is against you. In any case, before even this charge sheet is drawn, it is that charge that is against you, the offense that they allege you have committed, is what you'll be told, for which you'll be asked to give your statement, be the investigation caution statement and the charge statement. Now they put you before court. What next? If you have already not been granted bail, whenever they put you before court, when the case is called, you can raise up your hand if you do not have the assistance of a lawyer and tell the judge that you want to be granted bail. But the fact of saying you want to be granted bail is not a sole ground by which the court will grant you bail. You need to convince the court that you would appear to come and stand trial. So you need to tell the court that yes, you have sureties, people would make sure that you come and stand trial. 2, that you have a fixed place of abode, that you are gainfully employed, and that you ensure that the charges or the evidence that's against you is not so strong in such a way that you would want to run away from whatever punishment that may be meted out to you. That is the issue of bail, asking for bail. Once you say all that, the judge will record you, and you need to take your time and speak clearly to the understanding of the charge. So a case is called, the charges are read to you. If they are ready to start prosecution, they will say they are taking your plea. Now your plea is your answer to the charges that has been preferred against you. So you may plead guilty or not guilty. Now there's another one which says guilty with explanation. So some people may say, yes, I am guilty, but this is the reason why I did it. Now remember, you should be very careful before you take your plea. If you do not understand the legal implications of the charges, or you do not understand the charges that have been given against you, please consult a lawyer before you take your plea. The best thing to do is to consult a lawyer, and not any other person, but a lawyer, because he's the one who has been trained in the law. Do not go and plead guilty to anything if you do not understand the legal implications. Because once you plead guilty, the next thing they'll do is to convict you and sentence you. So what if you decide to plead not guilty? Now if you plead not guilty, what the judge is likely to do will either remand you if they do not want to grant you bail, or may grant you bail. It is always important for you to raise up your hand to ask for bail. It is not automatic that the judge may grant you bail. If you are already on bail and you are by the police, that's the police inquiry bail, you appear before court, you ought to ask formally again for bail. Because once you are put before court, you could be remanded in prison custody or be remanded in police custody. So you need to formally ask for bail. You don't need to be afraid of anything when you are in court. The truth is, the court is for us. So you just need to know exactly what you're supposed to do when you get to court. Your phone should not be on. You cannot talk rudely to the judge. You cannot have a hat on whilst you are in court. You need to understand the ethics of court. And if you come to even observe proceedings, you are supposed to have your phones off, because when your phone rings in court, it is contempt of court and your phone can be seized. So what next? The charges are read to you, you plead and you say you are not guilty. The court would have to go into the offense that has been brought against you. So they'll ask for the prosecution, that is the police or the Attorney General's office, to furnish the court with what we call disclosures. Disclosures are all documents they seek to either rely on for the prosecution or they have gathered in their investigations which may be necessary for you. It could be documents that even inure to your case as an accused person. Take note. When these disclosures are served on you, you are supposed to go through everything. If there's any information that has been obtained or there's anything that has been obtained by the prosecution or the police during their investigations and they have not given it to you, you need to draw the attention of the court. Usually, they are supposed to serve you these disclosures not less than 3 days to the time where the court will sit to do what we call a case management conference. The trial process we go on. The court may set a date where they start the trial. And by the trial, we are saying that the prosecution should come and furnish evidence. So they will bring witnesses. Now, every witness that the prosecution you bring, you have an opportunity to cross-examine the person. But even before the cross-examination, now, by virtue of what we call case management conference, the evidence that they are going to give, it will be typed out and written on paper. If you look at it, at the point of presentation of the evidence, if you have any objection, you can raise the objection. And the objection is raised when the person has entered the box to testify and begins to say, this is what I want to put in as my testimony. If you have any objection to any particular thing in the statement, say that, my Lord, I object to this particular part. You raise up your hand. The court gives you opportunity and you raise your objection. If you do not have any objection, it goes in. It means you have accepted that whatever they want to say, whatever they want to testify, it should go in. Then after that, the court will give you an opportunity to cross-examine the person. When you have opportunity to cross-examine the person, you must ask relevant questions. You must ask questions which border on the crime which they allege you have committed. Do not go and ask questions as to whether that day you were wearing a red shirt or a blue shirt. But remember, if those questions are very vital to ensure that your guilt is, established, or are very vital to ensure that your innocence is established, then you can ask those questions. Asking relevant questions is very important. The court would aid you if you are not asking the questions in the right direction. What I mean by that is that they may reframe your questions so that you are able to make a very good, you're able to make sense. Now, after a witness comes and cross-examines the person, the court will discharge that witness. If the prosecution has another witness, they may say that they want to bring that witness that same day or another day. You have every single opportunity to cross-examine that witness who comes. Remember, whatever you are doing is try to ensure that you are establishing your innocence. But if you also know that you are guilty or you have committed the offense, it is important to take the earliest advantage to say, I am guilty. In fact, you could have pleaded not guilty at the beginning. While the trial is going on, you can decide to plead guilty. And once you plead guilty, the court will convict you. That means the court will find you guilty and next would sentence you or punish you, depending on the kind of punishment that may be given to a person. So always, before you plead guilty, you must know exactly what you're doing. So the prosecution will call all the witnesses. You have opportunity to cross-examine them. Usually, the last witness may be the investigator. Now, that investigator would come and tender in the investigation caution statement he obtained from you. If you confessed in that statement, it will be tendered. If you take any objection and the court is of the view that they have to go into that objection, then they will conduct what we call a mini trial, what is referred also to as voir dire. Now, when they conduct a mini trial and they establish that that statement was given voluntarily or was given in the presence of an independent witness, either both of them, voluntarily and in the presence of an independent witness, the court will admit it in evidence and will allow the investigator to go on to testify. After he is done, you have opportunity to cross-examine the investigator. The next thing you also need to know is that after the prosecution is done calling all its witnesses, they will tell the court that they have closed their case. Now, when prosecution closes its case, it is the court's duty to decide whether a prima facie case has been established against you. Now, usually, lawyers for the accused person may raise or draw the court's attention that they want to file a submission of no case, meaning that there's no case, they have not established the ingredients for the offense for which you should come and defend yourself. If that opportunity is given to the lawyer, he files and prosecution may decide to reply. Now, the judge is mandated to decide whether a prima facie case has been established. If a prima facie case is established, then what you are saying, what the court is saying is that opportunity has been given to you for you to present your defense. You may have a valid defense. So you put together your witnesses and the court may ask you whether you want to file witness statements. So you file the witness statement together with all the witnesses you are bringing along. Now, when your witnesses also come, they can decide to enter the witness box to testify. And when they take that opportunity to testify, the opportunity is given to them and they testify. You may also decide that you enter the witness box to testify or you stand to give a testimony, after which you will not be cross-examined. If you enter the witness box there will be cross-examination. That is, they will ask you questions. But if you do not enter the witness box, whatever statement you make will not be cross-examined. Remember, the weight to be given to the statement that you make when you are not in the witness box would be lower as compared to the one that you are in the witness box. So take notice of that. So when you call your witnesses, they are cross-examined, and you end your case, the court would then take opportunity of asking for addresses. If addresses is a sum up of everything that is the law and the fact that have been led, or the evidence that have been led, then they decide on the case. So a judge may adjourn and take a date to give judgment. Now on the day of judgment, the judge may, after the judgment, find you guilty or not guilty. If you are found guilty, the judge may ask you to say something, if you have anything to say, before sentencing is passed. That is, the punishment is passed on you. If you are found not guilty, what the judge is going to do is just to discharge you. So we'll tell you that you are acquitted and discharged. Acquitted means that they have not found you guilty, and the next thing the judge must do is what? To discharge you. Now let me take us back a little bit. If the court is of the view that at the time prosecution closes its case, that they have not established any case against you, you are acquitted. So that's all. There's no case against you, so nothing is going to happen. The case ends there. That is all. So you are free to walk away. Now at the end of the day, when the court gives its decision finally that you are convicted and any other thing, well, if it's prison, they will send you to prison. But before that, if you have anything to say in mitigation, you may tell the judge maybe you're a first-time offender, you've never committed an offense before, or you have been of a good character. This is just unfortunate. You may ask for clemency. You may show the reason why the court should be lenient towards you, and the court would go ahead and give a sentence. You may be fined depending on the offense, or you may be sent to prison. Once the court gives an order that you are sent to prison, what the court will do is that they will issue a warrant. Now when you are sent to prison, you become what? A convict. Now when you get to prison, all the necessary details, all the things they have to take from you will be taken, including your term of imprisonment. Now you have opportunity to appeal against that decision. Usually, appeal is in 1 month, except for offenses on indictments like murder and others, where usually the appeal is within 3 months. Now, even within the 1 month, if you're not able to appeal, you have opportunity to ask for extension of time within which to appeal. All these resources are available to you, and you can write to the registrar of the court to give you the proceedings of your case. That is what you will use to be able to mount any appeal. Remember, in all these processes, you have to be focused, because when you lose focus, you are likely to put yourself in trouble. Key thing, the courts are there to ensure that there's justice. Do not bribe any judge, do not go and bribe anybody, because when you do that, you are committing an offense. Thank you so much for joining us. We have been talking about arrest, bail, conviction, and then appeal. Join us on extvgh on YouTube and Explore TVGH on Facebook. Thank you for watching, and share this to someone. We'll be ready for your comments. And if you also want to sponsor the program, please see the numbers below and contact us. This is going to be a year of a lot of education on law. Thank you for joining us.
To support this program, contact XTV on 024-606-1095 or 050-836-4159, or send us an email to info@stvgh.com.